CPC important questions unit 2. Who are the parties to the suit? Discuss joinder of parties and effects of non-joinder. Who may be joined as plaintiff and defendant? What are the effects of misjoinder and non-joinder of party? Misjoinder of parties. Distinguish between misjoinder and non-joinder of party. Joinder of parties. Note of misjoinder of party. State the provision relating to joinder of parties. What is the effects of non-joinder of necessary parties? Introduction. A suit is a legal action initiated by the presenting a plaint to the court or such officer as it appoints in that behalf. Section 26 to 35B Order 1 First schedule of CPC deal with the procedure related to the suit. Essential of suit. There are four essential of suit: opposing parties, subject matter, cause of action, relief. Parties to the suit. Order 1 of CPC. The plaintiff and defendant are two necessary party to every suit. However, there may be any number of plaintiff or defendant in one suit, but at least one of each is necessary. Necessary party. A necessary party is one without whom no order can be effectively made. Proper party. A proper party is one who in whose absence an effective order can be made but whose presence is necessary for the complete and final disposal of the case. Joinder of party. Joinder of party means joining several party as plaintiff or defendant in the same suit. The main purpose of joinder of party is to ensure that the suit can be finally and conclusively decided on merits in presence of all parties. Joinder of plaintiff. Rule 1 Order 1. All person who may be joined in one suit as plaintiff where the right to plaintiff exists in the plaintiff jointly, severally, or in the alternative. The right to relief allegedly to exist in the plaintiff must be in respect of the same act or transaction or series of act or transaction. If such person brought a separate suit, may common question any common question of law or fact to arise. If the above three conditions are satisfied, several persons may be joined as plaintiff in one suit, although their cause of action may be separate and different. Joinder of defendant. Order 1 Rule 3. Order 1 Rule 3 speaks about who may be joined as defendant to the suit. Several persons may be joined in one suit as defendant if the following conditions are satisfied. A. The right to relief must exist against such person jointly, severally, or in the alternative. The right to relief alleged to exist against such person must be in respect of the same act, transaction, or series of act or transaction. See, if the separate suit were brought against such person, any common question of law or fact would arise. All these conditions must exist together for applicability of this rule. Representative suit. Rule 8 Order 1. According to this rule, one person may sue or defend on behalf of all persons having same interest. This clause was added with an Amendment Act 1976. Objects. Avoid multiplicity of proceeding, prevent from delay, facilitate decision. Essentials. They must have numerous person, group of person, same interest, common grievance, permission from court, notice to parties. Non-joinder and misjoinder. Rule 9 Order 1. Non-joinder. A man joined is a person who is necessary or proper party. He has not been joined as a party to the suit. Misjoinder. It is a concept where two or more persons are joined as a plaintiff or defendant under rule number 1 and 3. They are neither necessary party nor proper party. Provision Rule 9. The suit cannot be dismissed on the ground of misjoinder or non-joinder provided that nothing in this rule shall apply to non-joinder or a necessary party. Rule 13. Objection as to non-joinder or misjoinder. All objections on the ground of non-joinder or misjoinder of party shall be taken at the earliest possible opportunity. Effects of non-joinder of necessary party. Effect of non-joinder of necessary party. A suit is not to be dismissed only on the ground of non-joinder of party. The court may allow necessary party to be joined in at a later stage. Rule 9 order. Nothing in the said rule applies to non-joinder of the necessary party. The defender has to claim a non-joinder of party at the earliest in written statement. Case law. Lakshmi Shankar Hari Shankar Bhatt versus Yashram Vasta. In this case, the Supreme Court was of opinion that the court has the authority to refuse the dismissed of the suit on the mere ground of non-joinder of party the, or parties. The Honorable Court also upheld the significance principle that in any suit claiming property until all the claiming parties or co-owner are parties to the suit are present, the suit shall stand unmaintainable. In the case of non-joinder of the necessary party, the opportunity should be given to the plaintiff as well to add the necessary party. The Calcutta High Court, in the case of suit for recovery of money against LIC, it held that all the heirs of the claimant claimant would be necessary party to the suit and non-joinder of them would be bad. Rule 9 applies to the mortgage suit as well as to other suit. In a suit for redemption of mortgage property where the dra- mm, daughter of the mortgage who were necessary party were not impleaded and objection as to non-joinder was not raised at earliest opportunity, the suit cannot be maintained on account of non-joinder. The Supreme Court held a candidate who had withdrawn before contesting election was not a necessary party and so his non-joinder was not a fatal to maintainability of the election petition. In the absence of necessary party, the court may dismiss the suit as it shall not be able to pass on effective decree. But a suit cannot be dismissed due to absence of non-necessary party if the court general is legal. Court found it legally. If a suit is dismissed straight away for non-joinder of necessary party, the plaintiff will have to file the suit again, resulting in the multiplicity of the litigation. For this reason, the court may add the necessary party on its own or may even direct the plaintiff to do so. Case law. Brij Kishore Sharma versus Ram Singh. In this case, the Supreme Court held that the suit is not maintainable, as if one of the party died and his legal representative were not brought on record. In the opinion of the court, the legal representative should have been brought on record. Consequence of misjoinder of party. When any party or parties are added mistakenly to the suit under Code of Civil Procedure 1908, terms as misjoinder. In case where the misjoinder has added or joined to the suit, the court should not dismiss the suit. Instead, should or may order any decree, as the order or decree should not bind the misjoinder, and the claim or relief should be any for the necessary party only. Misjoinder of the cause of action can be further categorized into three party, namely misjoinder of the plaintiff and causes of action, misjoinder of the defendant and cause of action, misjoinder of the claimant. Conclusion: the misjoinder and non-joinder are parties are covered under Rule 9 Order of 1 of CPC. It is complete discretion of the court to decide on dismiss or refusal of suit due to the misjoinder and non-joinder. However, the suit can be maintainable by the court, and because of misjoinder and non-joinder, it cannot be dismissed by the court. The provision is not applicable in the case of necessary party to be in suit.